I'm back now, so I can start the recording. Thank you.
We're good, Mix.
All right, thank you.
We're being recorded.
Thank you. Let me announce the case. This is the matter for encroachment permit application number L97S1081C. It's case number PH-2022-NAV-10-001, and it's often been referred to as the pre-LPA logs case. The applicant is Gregory Wilson. Some of you have already been introduced to me because we've had some pre-hearing conferences, but for everyone else, I'm Karen Sheehan. I'm with the Attorney General's office. I'm a Deputy Attorney General, and I'm with the Fair Hearings Unit. So I've been appointed by the Idaho Department of Lands to serve as the hearing coordinator in this case. Today's date is December 19th, 2022. The hearing is set for 9 a.m. Pacific time, and it's currently about 9:03. We are in the Idaho Department of Lands office in Coeur d'Alene, Idaho. This is the scheduled place and time for the hearing, as I've just stated, case number PH-2022-NAV-10-001. The hearing is related to Mr. Wilson's application for what's being called the pre-LPA logs encroachment. My responsibility is to consider the application and the written record, take public comment, and determine whether the encroachment meets applicable statute, rules, and case law. I am then tasked with issuing a preliminary order that will be reviewed by the Director of the Department of Lands, who will then issue a final order. I reviewed the agency record, which is also on the Idaho Department of Lands website. And I'm just going to read through everything. There were a couple of additions yesterday. So I have 14 documents. Document 1 is application L97S1081C. 2 is supplemental letters to the application. 3, Idaho Department of Lands denial letter to applicant. 4, applicant appeal and request for hearing. 5, notice of appointment of hearing coordinator and scheduling conference. 6, the record from case number PH-2020-NAV-10-001. 7 is notice of the public hearing. 8 is the applicant's objection and protest. 9 is Idaho Department of Lands notice of filing and exhibits. 10 is the applicant declaration memo of authorities in support of permit issuance and exhibits. 11 is applicant confirmation of document and page numbers of exhibits. 12 is objector legal memo supporting denial of application and requiring removal of encroachment, hearing statement, and PowerPoint slides. Now, these are the documents from yesterday, so hopefully I have this correct. If not, Courtney will fix it on the website, but I have is 13. Applicant response to ID Held's request, information, restatute, notice, and declaration. And then the applicant added exhibit O, which I've marked as 14. So I've already reviewed this with the people in the front of the room when we had our pre-hearing conferences, but for everyone else, this is how things are going to work today. I'm going to have presentations first. Testimony and evidence from Mr. Wilson, then from the Objectors Council, then any others who have signed up on the sign-in sheet who have said yes, they want to make comment. Then I'll hear from the Department of Lands. Then I'm going to give the applicant, Mr. Wilson, the final opportunity to respond to any issues and make closing remarks. So just a couple of things before we begin. Basically, these are my rules, also just some further information. Please be respectful and courteous to everyone here. This hearing is being recorded, so please speak clearly. Please start by stating your name and spelling it for the record. There's no swearing in today. This is a informal public hearing. Actually, that was my next one. This is a public hearing for time to take public comment, so please direct all comments to me. If you're a member of the general public, not a party, your comments will be afforded equal consideration. I may ask questions. So there's no cross-examination or other questioning today. I may limit testimony that's duplicative, and I may ask the presenter to remain on task, begin to wander, and presenters may defer to legal counsel or specialists. Also, if anyone wishes to submit written comments, please submit them after the presentation or when I call on that individual. So if someone has said they want to make comment on the sign-in sheet, but they prefer to make a written comment, just let me know. And all written comments have to be received by the end of the hearing this morning. So I'll open it up. Any questions about the process this morning? Thank you. Well, with that, Mr. Wilson, you get to go first.
Okay. I'd like to start with a little background. I don't know how much you've read of what I submitted, but Bill and my family have been neighbors since 2003 when I purchased the lot of his. And it has good relations. I'd say we're good now, with the exception of the contest at hand. But this whole matter began in about 2018 when Bill removed a large concrete fixed pier on his property, which was about 20 or 25 feet from our common boundary. And subsequent to that removal, his beach began to experience considerable erosion. And that erosion took place really in the summer of 2019 and 2020. And in the late summer of 2020, Bill sent me an email demanding that I remove this log crib structure and the rocks that had been placed on top of it. Just by way of background, this log crib structure was principally not visible from the water, other than the rocks that were on top of it. We took a boat ride this summer just to see if there were other types of jetties or spurs on the lake in our subdivision. And Diamond Park has about 58 lots in the plat. There are 26 lots that had spurs or jetties. Now, this is not uncommon because people clear their beaches of these glacial rocks, which are a form of cobblestone, and usually windrow them on one of the boundaries. Typically, there are hundreds, if not thousands of them, obviously. So anyway, Bill demanded that we remove this because it wasn't permitted. Now, I didn't really know anything about the Lake Protection Act as being a lakefront owner. And even though I'm a lawyer in Idaho, I haven't had any experience about it until 2018. So unbeknownst to me, it wasn't permitted. So I got in my truck and drove down to the Kavanaugh Bay office and met with Trevor Anderson, who was a resource specialist in 2020. And I said, Trevor, I've got a problem with my neighbor. What do I need to do to solve it? And I explained it to him, and he suggested that I make a riprap application. In other words, permit the existing structure as a riprap. Riprap is a form of rock structure designed to mitigate wave action and reduce erosion. So I filed this application, and he sent me an email and said, your application's been approved. Permit will be issued on November 5th, unless there's an objection. So Bill objected on the 26th of October, and we went to that hearing, which took place December 3rd of 2020. It resulted in the order in January of 2021 that said I had to remove the rocks that I had placed on top of it. So that April, not being able to find anybody to go up there and work, Deborah and I did it. But we took a day off and went up there and removed them. And then I called Mike and said, Mike, we've complied with the order. We've removed the rocks, and come take a look. The order had encouraged us to make an application for a pre-LPA encroachment for the log structure that was now visible because of the rocks of it. So after Mike and his team came up, I think it was April 30th, and they inspected everything. And yes, we had complied with the order. We got a clearance letter on, I think it was around May 5th. And Trevor in the meanwhile said, in conjunction with the navigational permit application that I made in April, May of 2021, he said, you need to file for this pre-LPA permit by June 23rd, or we'll bring an enforcement action and issue you a non-compliance letter. So I prepared that application. It was prepared under the Idaho Code 58-13-12, which is the pre-LPA statute within the Lake Protection Act. Filed it on the 15th of June and waited and waited and waited. And I didn't hear anything the rest of 2021. Luckily, I contacted Mike Gamer in January and said, Mike, what's going on? Is there a decision being made? And he indicated that legal, I think, and others had determined that I hadn't complied with the requirements of that statute. And I asked him if he could detail that, exactly what I had. And think his general response was, well, we don't really comply with the substantive documentation requirement of the statute. So I asked Patrick Phillips, who is my neighbor to the north, if he would supplement his letter and provide additional information that indicated the log structure had not been modified since his recollection in 1966. And he did that. And I supplemented that, and I'm working at this point to try and resolve the matter and come to some kind of a resolution with the staff. And I think we had some other exchanges in the spring, but I didn't hear anything until July 8th when my neighbor sent me the letter that said, basically, it's denied, tear it out, along, and as well remove the rocks, the cobblestones that were placed in front of your pier bulkhead between underneath the ramp. So that's really those are the facts about that. My legal arguments, which I'm not going to go through the briefs that I filed. That my biggest objection here is that this hearing on this application was supposed to take place in the 90-day period before June 15th. We were in I believe, one of our scheduling conferences. I believe IBS Council argued that it was unclear. This 58-13-12 was unclear on how to deal with application processing that might be subject to a denial and a request for a hearing. And my brief specifically points out that Idaho Administrative Procedure Act 20.03.04.030 is titled processing of all other encroachments. So it is clear to me that that regulation provides guidance on how to deal with hearings concerning denials of applications on a pre-LPA application and the processing requirements. And they really do track the 1306C appeal procedures. So not having been done, I challenged Ideal's jurisdictional authority to hold the hearing. I think today is day 558 or 52 since I made the application on June 15th. So we're well beyond the statutory requirements for holding a hearing. So it's my legal opinion as a lawyer in Idaho for 34 years that IDL would have jurisdiction to bring this to hold a hearing or conduct a hearing. That opportunity left September 14th, 2021. I don't even think we get to the merits of this discussion today. I think the hearing is illegal and void. That's my argument. Concludes my comments.
Thank you, Mr. Wilson. School board. Would you like to go next?
Dr. Falloon will do his presentation and then I'll follow up.
Okay, please go ahead.
PowerPoint up there.
Yeah.
Can you do it from there, Mike?
What are you trying to do, Mr. Bloom?
He's got the PowerPoint on the flash drive.
Presentation I gave you? Okay. So, how about I just, which of the two up there would you like to turn on? One?
It's C, yeah, yes.
Who's going to run the PowerPoint then?
Yes. John, you want, can I run here or? Yeah. If I can do it, Bill Scott this time. How to use this and see.
So, Doctor, normally in these hearings, everyone stays in their spot. I know
Oh, okay.
the PowerPoint presentation. Can you run it from back
Oh,
there?
sure, I thought it'd be easier, yeah.
But you're directing the comments to me, not to
Okay,
them.
no, that's no problem.
You're gonna need that to click on the side.
Yeah, so that's fine. So I'm going to converse with this.
That's okay.
And And I can always just run it from
Yeah.
my screen share via Zoom, if that's easier, but since it was loaded on the thumb drive, I thought I wanted to control it.
But
Where should you point it? There you go.
that's not mine. It's not mine.
Why don't I just log in and do a screen share?
It's at 84%. It was a 17,000, almost 18,000 kilobit file. Taking a little bit to load.
Well, in the meantime, let me, if you want, I will. You can't really see that diagram I made, so I made pictures so if people want as a reference to get oriented about the neighborhood of Priest.
Just give them to the hearing coordinator.
Okay, nobody else wants one?
No.
I'm the only one that
Matters.
is making
Then
it.
here's some,
One way of looking at it.
Also,
okay, so.
Director is the only one that matters.
Here's some facts, some additional facts, I'll refer to those possibly, but
So these will be entered into the record, though. I'll have Courtney. So why don't I'll make these,
Oh, good.
I'm gonna make these 15 and
It needs to
16.
get shared onto the thing so that it learned off with the things.
Yeah, if it does, if we could share this computer, if this doesn't load up, then she'll use hers and share.
Is yours already loaded?
check. It's already loaded on my computer, yeah.
I get started talking while we get that.
Yes, please go ahead.
Just, I'm Bill Balloon, that is Brack ALOON. We're the Wilson's, replay. Before I get started, a few things, I just want some simple facts about Priest Lake. I don't know if you've been up there or you know, it's 19 miles long, widest is 4.4 miles wide, and it has 72 miles of shoreline.
Hey, guys, this is Mick. I went ahead and made Michelle a co-host, so she should be able to share her desktop if she wants.
Okay, she has share capabilities.
Continue on or should I wait?
Please go ahead.
There you go.
As soon as I say that.
Looks like it's running okay. How is it on your end, Mike?
I think it's good. Thank you, Mick.
Okay.
Let me just.
Okay, all right, sure.
Switching to share screen.
It's already shared.
It is.
Otherwise, it wouldn't have shown up on here.
Thank you.
No,
Yeah. Okay.
go ahead.
Team, just general facts about Priest Lake before we get started. There's a question about the ordinary high water mark or official high water mark. I call it the high water mark because there's only one high water mark that's used by the state of Idaho. And that number is 2,437.64 feet. You may refer to that later. It was determined by a case of Hudson versus IDL. And so if we will maybe talking about that some during this case, during this discussion or report, but you go to the first, next slide. I purchased property pre-slate in 2002. And this is a picture of the property. This is the that is my red boathouse. Well,
No, I'm doing it here. That's not Dunn's.
I'm trying to do my pointer. But anyway, that's my red house. That's the old cabin, which has been changed. The property has 75 feet of lakefront, and to the left is where the Wilson's cabin and property is. You cannot see it. Right, if you look at the end of this old dock, that is what Greg has referred to as a monolith. It's 2 cement blocks. It was had a wooden pier between the two, and so you see the dock is in poor repair. And so one thing that we decided to do when we first purchased the property is get a new dock. Go to the next slide. Again, that's a picture of there's the monolith. You can see the cement blocks. The monolith essentially acted as an approach. Go back to the slide.
It takes a while, like sort of a delay.
Okay, so we're too far ahead. Here's go to the previous slides.
I'm sorry. Maybe we should use the,
Yeah, it seems like there's a big delay. You're going the wrong direction.
yeah.
Anyway,
I also have them printed out, so.
I think it's good to people really understand what.
We have hard copies as well, so maybe keep going.
Okay. Anyway, the dock was in poor repair, and I decided to have it replaced. But in retrospect, during the hearing we had in December of 2020, Greg Wilson documented pictures of the neighborhood, an aerial picture of the area where the cabin is located, or actually our cabins are located. And wish I could show you the picture, but the picture F4 is a picture of the neighborhood, but the initials of the neighbors is on each property. And I magnified the picture.
Should be coming back, sorry.
And you can see, and there's, okay, go to the next picture. Again, W is for Wilson, F is for Falloon, A is for Aspen, P is for Phillips. And there's a magnified picture. In fact, this picture was taken, somewhere between 2006 or 7 and 2018. The reason why I know that is because that's an aerial picture of the Wilson's new current cabin, which was replaced, was built in approximately 2006 or 7. And the monolith that you can see there, which points to the erosion, was still present. And I removed that in 2018. But you can see on the Wilson's property, the shore is present there, and then to the south or right of the monolith, you can see how the shore indents or goes in, because that's due to the erosion that are present. So the monolith, if you will, was causing some erosion of my property. As the property in front of the boathouse is approximately 12 feet of from the property line to the south end of the boathouse. So I had approximately 12 feet of shore of my 75 feet of shoreline. It was sandy. Next slide. In 2003, I replaced we put a new dock in. Here's a picture of it. And in 2004, again, there's the new dock approach. You can see to the left, the cement blocks monolith, and you can see some of Wilson's old retaining wall there to the left of Red Boathouse. And if you look at the shore, there's no barrier and there's no erosion. In 2003, the Wilsons purchased their cabin and property from the Ellingsons. The new dock is about 15 to 20 feet south of where the old dock was. The next picture. In 2005, here's a picture taken from the dock. Again, this is, you see the Red Boathouse. There's basically the Wilsons shore with their old cabin, the green cabin in the back, their boathouse, green boathouse to the left, and the shore. And you can see the rail system to my boathouse, and there's no barrier present there at the property line. Again, you can see their old retaining wall runs parallel with their property. Next slide. In 2006, approximately, the Wilsons decided to replace their old cabin with their current lake home. In order to do that, they had to apply for a permit for, they wanted a new domestic water line to their new cabin. This is the picture that was done in April 18th, 2006. Again, their domestic water line is approximately 10 feet from our property line. And there's no, as the large red circle documents, there's no barrier or wall present there or diagrammed under their, as an aside, under their dock, the small red circle, there's no jetty or rocks present there. Next slide. This is in comparison to in 2021, this is getting a little ahead of us, when the Wilsons had a after the fact permit for their rail system. They had, was previously owned by the Brophies, who owned a lot to the north of them, and Wilsons purchased that. And this shows the rail system in the blue circle that they had to apply for an after the fact rail system. And now in their diagram, it shows the rock barrier at the property line, with the big red circle, and another rock barrier under the approach to their dock in the small red circle. So there's been a difference between 2006 and 2021, meaning that there's now a barrier visualized there. And it wasn't there in 2006. In 2018, I decided to, after doing a lot of work, our cabin is definitely a fixer-upper, to start working on the beach. As I had a large retaining wall running parallel with the beach, as you may have seen the first couple slides, and then the monolith, as it's called. Before I removed those, I did call IDL at Priest Lake and asked them, do I need a permit? They said, no, you don't need a permit to remove anything. So this is a picture on October 27th of 2018. I rented a jackhammer and destroyed the monolith. Okay. I then And please note, if you look in the background there's the Wilsons beginning a log on the beach with rocks going into the lake. And notice the distance between the end of the log and the retaining wall to the right, it's about, I estimate, 15 to 20 feet. Go next slide. And then the next slide.
It's coming,
Okay.
sorry.
Okay, I then removed, myself and hired hands removed and took all that rock out of off the beach. There it is, okay. And again, notice the log on the Wilson's Beach and the rocks going out into the lake. Next slide. In 2019, again, this was a 2018 that I removed that. 2019, Kelly, my partner, and I spent a lot of time, basically, the recommendation of Greg Wilson to rake the beach. This picture was combed down. It was of the beach that we raked to try to get rid of the rocks. Unfortunately, what you find if you rake rocks, you get more rocks. It's endless. But that is after raking rocks. But now you can see again the Wilson's rocks at the property line being built up. Now go to the next slide. Again, this is another picture, if it comes up, of the our beach. Okay. In 2020, the next slide, Falloons, my beach, continue to erode, and simultaneously the Wilsons built up their barrier at our property line. You can see, so it comes up here.
There it is.
So now, if you look at the log on their beach is approximately 2 or 3 feet away from their retaining wall. It had been moved up shore, and there's rocks, and now they place sandbags at the property line for a barrier, and you can see the erosion of our beach compared to the Wilson's Beach up above or to the north of ours. You can see how theirs is nice and sandy. And as for the next slide. Sorry, this is taking so long.
Yeah, it's
It's
F15
frustrating.
is the exhibit we're on.
Okay, well,
I've got it.
okay,
Thank
there's, we'll just go through, okay, there's another picture, it's all taken the same day. Next slide. Is it coming up?
It's up at 16.
Oh, 7, okay, next, no, it just shows the same, just showing erosion of the beach, so. Just several pictures on the same day. We go to F18, please. Again,
Coming up.
that's F18. So I still, no one accused me of being the brightest bulb on the tree. I still was trying to figure out what was going on here and why we had erosion. And so I went down on August 24th. This was taken on August 23rd, and talked to Trevor Anderson about this. And I told him that I had erosion of the beach. Wilson's had built the barrier. And it was my assumption at this point that I thought the flow of the lake was from southwest to northeast. That means coming from left going up, and I thought sand was, or big rocks were being accumulated on my side, but the sand, which is lighter, was accumulating on the Wilsons. And so that's what I thought originally, which like was wrong, but I thought the barrier was causing sand to accumulate into a filter to the north. Again, if you have the records, before I approached, I gave Trevor more information. I wanted to talk with the Wilsons. And so on September 1st, next slide, I sent the Wilsons an email. And I'd like to read the email. Try to maintain and improve our beachfronts. Unfortunately, the sand on my beach, especially in front of the boathouse, has progressively eroded and washed away. This is due to the barriers of rocks and sandbags you have created between our properties. Because of the flow of the lake, the barrier causes rocks to accumulate on our side while the sand filters through and accumulates on your side. I was wrong about that. I am not sure if the rock barriers beneath the approaches to your two docks are adversely affecting my beach or your neighbors to the north. In order for the beach on my property to stop eroding and return to a natural state, the flow of the lake has to be restored. Therefore, I would like the barrier that you created between our properties to be removed, preferably within the next few weeks. I'm happy and willing to help you with this. I would like to remain amicable, good neighbors and friends. Both of us want to maintain or improve our properties. This includes enjoying our beaches for recreation, improving the aesthetics, and maintaining our property values. Thank you sincerely, Bill Flynn. Both Greg and Deborah described this as abrasive. Greg also said this is a demand letter. I guess I thought it was not abrasive, but you can make a decision yourself. So I then went to Trevor, I emailed Trevor Anderson, and then Deborah talked to Shelley, my partner, on the following weekend, and she said that it was better for me to communicate with her rather than Greg. And the following week on Labor Day, September 7th, I spoke with Mike and Nancy Brophy. They are the previous owners of the Wilson's northern lot. I figured I wanted to investigate this, ask them, do they have any pictures or documentation of the wall? They did not. They own the lot just to the north of this lot, Wilson's. I then spoke with Deborah, and I spoke, and an email that I sent to both of them on September 10th. Deborah had the previous weekend had offered to help me build a barrier into the lake, including filling sandbags. She was just trying to be a good neighbor. But I said this would be, in my email to her, I said this would be similar to the one that you created. However, this is not permitted by the state of Idaho and may negatively impact the Aspens Beach waterfront. The Aspens are my neighbor to the opposite side, to the south. But she said, then on September 11th, I spoke with Zebby Ellingson. She is the owner of she owned the Wilson's cabin, and that's who the Wilsons bought their cabin from. And she had no documentation or records of the Wilson's beach, or their beach when the Ellingtons owned it. And her husband, they're divorced now, Chris, he was in Costa Rica the last time she did. So anyway, Deborah and I spoke on September 12th, and she said that she had pictures from 60 years ago that documented that the barrier was there. And I said, okay, Deborah, could you please send them? And so I emailed her, and then on September 15th, I emailed Deborah, and I said, I sent her pictures, and I said, please send or email me pictures that you have from 60 years ago on our beach, as well as other pictures of our beach taken previously. So Deborah sent me 3 pictures This is a picture, one of the pictures you took. This is what was taken obviously after 2006 or 7, because Wilson's retaining wall is new, and that's what was built when they built a new cabin. You can see my red boathouse to the in the distance, and you can see some rocks there at the property line. But there's no real erosion of our beach. That was before the models was removed. This is the second, another picture that Deborah sent me. It's difficult to see, but it doesn't show a barrier there, but that's not a very good picture to evaluate the beach. Anyway, next picture, next slide. In September 12th, I took, pictures. Frustrating. Well, not good. I'm going down right. The picture.
Go ahead, it'll
Okay, well,
shrink
anyway,
back down.
it's not much to show. It just shows first the wall being built up and the rocks there. Next picture. Again, these pictures were taken on September 12th. 2 weeks later, on weekend of September 27th or 28th, I went to the beach, and next picture, and noticed that the Wilsons had put an additional sandbag out on their barrier, and I didn't know why it was. Next picture. And this is a magnified picture of it. And well, why is that sandbag out there? Because it never had one. All were close. Well, you can see the water's rough. It's difficult to see because the waves are there. But the next morning I went out, and next picture. And there, when the water's calm, sand had filtered through the Wilson's barrier from their side to my side. All of a sudden the lights went on, and I realized I was wrong. The flow of the lake is from north to south, not what I originally thought. And they placed the barrier, the sandbag there, to prevent sand from going on my side of the barrier. I mean, this kind of irritated me that give me a fighting chance to have some sort of a beach. And and that's what's true of every place on Priest Lake or in our neighborhood. Sand accumulates to the north of a barrier and is eroded to the south. That's what happened when you saw the original picture. When I showed you with the beginning of the aerial view, my beach was eroded to the south of the monolith. So go ahead, next picture. Oh, wait, stay there. Anyway, this is a picture of taken 2 weeks previously in August, and that extra sandbag isn't there, and there's no sand around my side. Next picture. So the Wilsons applied for a riprap on October 1st. And the riprap is for I think Trevor misspoke when he told him to apply for riprap, because it was later determined to be a jetty that they needed. But riprap is to prevent erosion of their property. Well, the Wilsons have a very well constructed retaining wall there on their, runs parallel with their beach. Anyway, on October 1st, they applied for riprap. Anyway, you can review that whole application if you want, but I'm not going to go through that. But I opposed their permit. In their permit, which I went through, I'm not going to. The Wilsons described 3 things they wanted to accomplish. One is to block 18 from to detail each work activity and overall project. 18 is the lot number, I assume. Number 2 is, they said that each spring, the lake floods 18 to 36 inches above the high water mark. And 3 is they describe engineering proposal. First of all, block 18, I own lot 16, they own lot 18 now. So they were going to block themselves to their own construction. They misprinted or whatever. I then went to the USGS records and evaluated the past 21 years of elevation of Priest Lake. And I'm not going to go through all the details, it'll take forever, but of the past 21 years, the lake was elevated 18 inches or higher 2 of those years. 2 of 18, 2006 and 2018. And of those, a total of 19 days in 21 years, the lake was elevated 18 inches or higher. The highest ever got was 24 inches above the high water mark, and that was for 1 day. So it does not rise up every year, and it rarely goes above 18 inches. I'm not going to go into detail, but their engineering plan had multiple incongruities and inconsistencies. Their diagrams were not consistent with their written descriptions. It was a flawed proposal. I'm not going to go through all of it because there are many inconsistencies. Yeah. Okay. And then okay. Well, anyway, just go. I made a model of their barrier proposal and go through real quick because I made a model of the barrier and it was actually going to be bigger than what they had at that time. Next picture. That's the model that I created. That's good enough. I guess the meeting in 2020, December 2020, was structured the same way this is. Wilson spoke, Falloon spoke, and Wilson speak. After I spoke, Greg spoke, and did I go through these or not?
There's no reason to repeat from the
Okay.
2021.
Okay. Anyway, you can read it on yourself in my document. Anyway, the Wilson's barriers were was denied in December of 2020. I then spoke to or emailed the Wilsons. I did not want, if you read through my emails to them previously, I never wanted a legal action. I wanted this to be amicable. I wanted to resolve this. So it was denied. That letter came out in January, early January, like the 3rd or so, January 3rd, 2021. I emailed the Wilsons. I also spoke with Mike Damer and Trevor Anderson about me doing all the work. And what that would be is I would create a barrier, remove the barrier at their property line, and I would move the barrier down 15 to 20 feet on my property for 1 year. This would help prevent, the sand being eroded away quickly. The following year, year number 2, I would move the barrier back. Move it south another 15 to 20 feet. year 3, I would move it back another 15 to 20 feet. I have 75, so it would take me about 4 or 5 years. I'll do this in the spring before the lake grows. And I proposed this to Greg and Deborah. And I also, talked to Mike Amer and Trevor. They said I had to get approval. Well, anyway, after Deborah emailed me, said, "Hi, Bill. Thanks for reaching out and continuing to seek resolution. We appreciate the effort you put into your proposal. We will include this proposal among our options to consider." So they, in February of 2021, the Wilsons filed an appeal for their barrier via their attorney, Magnuson. In February, I opposed the appeal. In April, I think it was approximately April, the Wilsons withdrew their petition for their appeal for this via Magnuson. And this forum and I just wanted documentation that they were going to remove the barrier, and she can address that, but I don't know if she ever got that from Magnuson and the Wilsons. But anyway, it was eventually appealed. As this Greg spoke, and this picture, Mike Amer and Trevor Anderson had a Zoom meeting with the Wilsons on April 29th of 2021. And they discussed about removing the rock barrier, and they went up there the following day on the 30th, and they said that the Wilsons themselves had removed the barrier that was over the log, and as well as the sandbags, and they said that they had moved back to remove the barrier up to the pre-existing log crib. Well, I appreciate them removing it, but one is the log crib. There's no documentation of it pre-existing. There is no documentation of it ever existing before, when it was put there. There's and also, as I said at the very beginning of this presentation, the Oregon high water mark is Priest Lake's 2,437.64 feet. But when you go on where is that on a beach? Is that high water mark here, or is it here? Where is it located? No one knew where it was located on the beach. Although it was a number, no one knew where it was located on that beach. So I opposed that there's no documentation of it existing before 1975. And then that's one picture that Mike Amer took on April 3rd. Go to the next picture. And here's a second picture. Okay. Again, I oppose that. And as an aside, on May 5th of 2021, when Mike, I think, was up there, he also said the Wilson had to apply for a permit for an existing rail system for the opposite side of the property to the north, which was owned by the Amers. Owned by the Brophies, excuse me. And I was sent a application approval for that, and I approved that. Anyway, next. So anyway, On May 7th of 2021. Okay, well, that's what we talked about before. So next slide. May 7th, 2021, I emailed Mike Gamer. Documented that I did not think that this was that log crib. There's no documentation that pre-existed before 1975 and it did not have a permit. However, in May 31st, there's a picture you can see. A picture of the Wilson's barrier on their shore persisted, and they put plastic wrap, whatever you want to call it, there on their side. It should be noted. One thing I should say is that when Mike Amer talked to the Wilsons on the April 30th, he said that sandbags and rocks appear to be moved above the ordinary high water mark. Although, again, it wasn't defined where that ordinary high water was. Above the high mark on the Wilson property. Mr. Wilson has agreed to move the sandbags and rocks further upshore in the event they are still located below the ordinary high water or ordinary high water mark once the lake reaches its summer pool. IDL has determined when the Wilsons complied with the final order. Again, I disagree with that. Okay, but Wilsons had agreed to remove things above the ordinary high water mark. Again, it's not really defined where it's located. But anyway, we'll get this. So keep on next picture. So this is a picture of their barrier. Next page, next picture.
At 44.
Give some
Filter just the letters.
what's that?
Skip the letters.
The letters.
That's what you're just.
Okay, well, continue on here. This okay. So anyway, now we're in July 4th of 2021. There's a picture of the barrier on the property on the shore, and the Wilsons have now put two jet skis, wave runners, whatever you call them, with lifts next to our property line. Now, lifts are what a lift is. A lift. You're supposed to lift them up into above the water, but those are downs, meaning they put them down for the intent of protecting their beach, protecting shore. Next picture. So there's, okay, you show me.
It's gonna shrink it in here.
Anyway, they put them there intentionally to block sand from filtering from their side to my side. On July 4th, that day, Deborah, Greg, and I met at the property line. And both said that originally, my original letter that I talked about on September 1st, previous year, was abrasive. Greg said that he put the jet skis and lifts on our property line just to see how long it would take him to get a response from me. He asked me how much I had paid in legal fees, and I said $15,000. He said, I would remove the barrier for half that amount. He said that he was doing this because I had won 3 times before because we had some disagreements. I'm not going to go into those, but I'll be happy to if you want more information. I said to the Wilsons, they told me that they were too busy to remove the barrier. And I asked them, I would be happy to do it myself. And they said, well, they want to do it themselves. And Greg said that, Bill, you're a surgeon, you do surgery and you fix problem that day. For him as an attorney, it's not uncommon for a case to take 5 years. Well, I guess that's come true. Anyway, so this is July 8th. So I asked them to move their wave runners. And go ahead, next slide. And they moved them. But what do? They put their Hobie cat. Next picture.
There it is.
Okay. They move their jet skis down the beach a little, again, keeping them low to the shoreline. And they put their Hobie cat there. The Hobie cat is not registered in Idaho. It's not registered, not licensed, and I checked with Idaho.
So we're just getting a little off topic here when we talk about items being unregistered. So I just really
Okay.
want to
Okay, that's fine.
concentrate on the encroachment.
Okay, that's fine.
We're getting, close
Sure,
to
that's
50 minutes now.
Yeah, okay, so, okay, anyway, they put their, Hobie cat there to block the sand, okay? Then the Wilsons, applied for, or Greg's signed a, permit, or application, for the barrier, and he signed that on, June 15th. But I never received it until I went over and spoke with Mike Gamer. On July 15th. About this, and at that time, he gave me the Wilson's permit application. I never received it. This was now a month after Greg had signed it on June 15th. I got it on July 16th. And at that time, Mike said that the reason why he approved the log is because it looked old. But there's no documentation of when that was there. Was it before 1975, 1980? When was it actually there? Again, no documentation. Though continuing the slide. So I objected to the Wilson's application 4 days later on July 20th. As soon as I got it. For the entire summer, the Hobie cat and the jet skis remain on the beach. Next slide, and this just shows the erosion or the sand accumulation on their side blocked by the log. There's sand accumulating around their jet skis and their Hobie cats. Next slide. Again, their wall kind of collapsed onto my property. That's September. Again, sand accumulated on their side. Next slide. That's end of September. They removed their jet skis. Now minimal sand on Falloon side. Lake level was down on October 16th. Slide. That's taken on December 1st. I failed to mention that Mike Gamer in his letter to the Wilsons has allowed the Wilsons to have until December 1st of 2021 to remove their barrier when he wrote that letter on April 30th. They requested that they had until December 1st to remove their barrier. On December 1st, I went up there and next picture, and this is a picture of December 1st. Lake level is down. Next picture. There's a picture of the difference between their side and Saloon side. Next picture.
For the record, we're at exhibit F66.
Okay, so they're the Wilson have removed their cat and the sand. You can see the difference between their side and my side. I forgot to mention that. Sorry, I'm going. I forgot to mention that in terms of the timing of things, on July 4th, excuse me, August 4th, I emailed Mike Gamer. And if you remember the we had fires up in Idaho and elsewhere, and I said, dear Mike, I assume that you and other members of IDL are inundated with work due to the fires. These take precedence over the conflict the Wilsons and I are having concerning our shore. Once the fires resolve, maybe we can have a meeting, or if needed, court hearing to completely resolve this issue. And Mike responded that day, thanks, Bill, sounds like a good plan. So, and I also emailed Greg Wilson on that day, and I asked Greg, I would appreciate it if you would move your white Hobie cat to the opposite side of the jet skis. If you need help moving it, I'm happy to assist or can move it for you. He responded 12 minutes later and said, the Hobie cat will be moved at the end of the season. Well, you can see here as a perspective, here's a picture taken of the Wilson's Beach on July 18th, mine on a week later, July 24th. There's a significant difference. I then emailed Mike Gamer multiple times on September 10th, October 1st, October 22nd. Unfortunately, Mike was busy. I guess I never got a response from him. I emailed Dustin Miller on November 3rd. Never heard from Dustin. I emailed the Wilsons on December 20th, asking them several questions if they were going to remove the rocks and the sandbags. Are you going to remove the log barrier at the property line by May 1st? Are you going to remove the jet skis, the Hobie cats? I never got a reply. Mike Gamer eventually responded to me, or spontaneously emailed me on February 3rd of 2022. He said, hello, Bill, just wanted to touch base with you and let you know I have not forgotten about the Wilson situation, and I'll be trying to resolve the matter later this week, early next week. He was busy. Anyway, we corresponded. He on February 17th, 2022, he left a left a voicemail for me saying that he had talked to Greg Wilson, and Greg was discouraged about the IDL's hearing, or IDL's ruling rather, and he was going to investigate getting letters about the log and barrier and property line pre-existed before 1975. Since I didn't hear much from the Amers, from my Gamer, I emailed Angela Kaufman multiple times. Again, I'm going to go through all those repetitive, I explained the situation to her multiple times. But then obviously nothing happens up there in terms of the lake from approximately October through April because the lake level is down. But then in May 19th, I went up there and the Wilsons had now put a tarp on their beach. Obviously to protect their sand. Next slide, please. On that day, the reason why I went up there on May 19th is because I had the second survey done on my property. And you can see the two flags are red and blue. Red flag is the property line, pink flag, and the blue flag is the ordinary high water mark. So now we have a defined ordinary high water mark. It's at the 2,437.64 feet. And again, the Wilson's barrier is lakeward of the ordinary water mark. Go ahead, next slide. Again, on this is a comparison on May 19th, the day of the picture, there's a ordinary watermark and the tarp, and 2 weeks previously, you can see the sand there. The reason why the tarp was there is to protect their sand. Again, you can see the difference between the Wilsons and the Lehman side. Next picture. Again, this is a picture taken 2 weeks later on May 28th. Now the Wilsons put a tarp over their rock wall, and they reinforced the tarp on the property with logs and wood. Okay, next slide. Oh, okay. Sorry, it's impatient.
No, it's just a
You can see they put additional rocks and wood over there. And you can see the lake is starting to rise through this spring runoff. Next. Sure.
exhibit at 73.
Just next slide. This just shows the
Flags.
shows the lake level being raised. Or next picture.
This one or next
Oh, okay. Right here. Again, this just shows the lake. Next slide. During this interim, I emailed Mike Hammer quite frequently. Just next picture again just shows the barrier and the ordinary high water mark. On June 29th, Brian Van Heusen from IDL and Priest Lake went up and inspected the Wilson's property, and he said that I found that there were a log with rocks and a tarp with rocks on it located below ordinary high water mark on the south end of the property. That's right here. The rocks underneath the Wilson's pier also observed below the ordinary high water mark. The logs and rocks and the tarp are unpermitted. Anyway, then he took multiple pictures documenting that. Next slide. Again, I took pictures. This is on July 2nd. You can see the erosion on the beach, plus above their barrier under their dock. Next picture.
F-79.
And on July 8th, Mike Hamer emailed the Wilsons that they did not satisfy requirement for their log crib, and it was denied. And if they wanted to, they could oppose this as of August 12th. He also said that the rocks and cement underneath their dock approach was not permitted, but that's a separate issue. But they had until August 12th to apply for to appeal this. They didn't appeal it till September 14th, month after the deadline of August 12th. This picture was taken in July, just documenting the wave action. It affects everybody's beach, balloons as well as Wilson's and everybody else's. During this whole process, I had contacted the previous owner of my property, Gary Thieves, and I'll just read this to you real quick. My family purchased lot 18 at Diamond Park Edition on Priest Lake in June 1965. We sold our cabin on lot 2 Bill Falloon in 2002. When we owned the lot and the cabin that we built, lot 17 and the cabin on it were owned by Red Grouse. That's the Wilson's property, and later by the Ellingsons. That's who Wilson's bought their property from. During some of this time, two cedar logs that were approximately 4 to 6 inches in diameter and 20 feet long were placed on the beach at the property lines by the Rouses. However, there was no rock barrier or rock structure that extended from the beach into the lake. In addition, there was no erosion of our beach. So it said at some time that were documented when what pre-existed before 1975 or whatever. Then Pat Phillips wrote a letter on June 15th of 2021. Wilson's got this. My family purchased lot 15, the Diamond Park subdivision, in the early 1960s. Our family, through a family trust, continues to own lot 15 adjacent to Greg and Deborah Wilson's 2 lots. Recently, Greg Wilson asked me if I had any recollection of the two cedar logs which have been placed near the south border of his lot 17. I recently walked over and looked at the exposed logs. My dad and I built our cabin in 1966. As a teenager, I recall walking the beach front from our cabin to a small creek where I would catch frogs. I recall stepping over logs on the Red Grouse lot 17 beach. I believe that Red may have tied up his fishing dinghy to the logs. Well, it doesn't really, that does not support the legal documentation, like having pictures or anything like that. And it doesn't, it's just not approximation. On February 22nd, 2022, Mr. Phillips signed another letter. I'm not sure if he wrote it or not. It sounds, I question that, but that's my own opinion. I, Patrick Phillips, offer this supplemental letter in connection with Greg Wilson permit application to a pre-lake protection act shoreline and lake bed encroachment located in the south boundary of their Priest Lake Diamond Park Edition Lot 17A. In June 2020, when I had presented the Wilsons with a letter presenting my recollection facts concerning the log structure on their southern lake front boundary area and their property and the permit application. Exposed log structure, which I inspected in the summer of 2021, is the same log structure that I recall seeing in the south side of lot 17 extends into the lake, although now much older and weathered. Anyway, you can read this. In 1966, I was 14 years old. Additionally, I recall seeing a dinghy up to a log at times at the location of the log structure. Anyway, read the whole thing. I don't want to bore it, but that is Michelle will address. That does not fit the legal description of a area. And anyway. Anyway, on July 23rd, Greg and I talked at our property line. Said he wanted to resolve this conflict, and I said that I would volunteer to remove the barrier. I said I would do it, but I said I would do this up in. I volunteered to do this up until August 9th of this year, and after that, they can take care of it. It's done July 28th, so that was about 2.5 weeks or so. But Greg never responded, responded to that, saying that I can remove it. So it was never removed. And there are multiple other emails to Mike Gamer and so I think you can see the history here. Mike Gamer in the discussion in December 2020 said that a log strip barrier cannot be modified, and it's apparent that the barrier at the Wilsons at our property line has been modified significantly, and they continue to place obstacles or barriers, including their jet skis and their lifts and their hovercraft and their tarp, that has negatively impacted our beachfront.
Thank you. Would you like to go ahead and Ms. Bolton?
Sure. I'll just briefly address the statutory and legal grounds for denial of this pre-LPA application. I think dealing first with this jurisdictional issue that's been raised, Idaho law is very well established and longstanding that the Idaho Department of Lands has jurisdiction over protecting the beds and banks of the waters of the state of Idaho. And whenever a property owner desires to encroach upon those lands between the ordinary high water mark or the artificial high water mark, they must obtain a permit from IDL. And this is established in Idaho Code 58-1301 et cetera. The jurisdiction with IDL governing these encroachments is unrebutted and well established over time. And so if the applicant wants a permit for this encroachment beyond the ordinary high water mark or the artificial high water mark, they have to go to IDL to get it, and they have to be granted. To now say that Wilson claims he's automatically approved because of claimed due process violations is not consistent with the jurisdictional powers granted to IDL under Idaho code. You don't get automatically approved. for any encroachment into the lake. You have to apply. The adversely affected adjacent property owner must have notice and the opportunity to object and participate, and then a decision on the merits is reached. And this notice and participation of the adversely affected adjacent property owner is important. Number one, the case law dating back to 2003, and I was with Luke and Zanetis. This was a case I worked on, Lovett versus Robideau, was a case tried before Judge Michaud up in Bonner County regarding an encroachment. And there, the Idaho Supreme Court affirmed the denial of the permit. And a similar argument to what Mr. Wilson is making was made and rejected. And that was that the adverse property owner doesn't have to participate or doesn't have to have the right to object. And this is exactly what the applicant, Mr. Wilson, told Mike Amer in a letter dated August 8, 2022, which, based on Dr. Falloon's presentation just now, this August 8 timeframe is exactly when Mike Amer had told him, you need to present your appeal materials by August 12th.
Can I interrupt you for 1 minute? I see you looking at your memo. Where did you cite that Supreme Court case in your memo?
I think it was in the previous materials that were incorporated.
Oh, the previous, okay,
Yeah.
thank you. Okay, I'll look at that, thank you.
We talked about it in the prior denial that Falloon as an adjacent adverse property owner is entitled to participate.
I didn't mean to interrupt you, please go ahead.
That's okay. The letter that Wilson sent to Mike Amer is a direct violation of the Lovett versus Robideau ruling. And it's a direct violation of Idaho Code 58-1305 subsections B and C. And the letter Wilson sent to Mike Amer on August 8th, 2022 says he's appealing his decision to deny the pre-LPA. And he makes a point of saying, this is between IDL and the state agency. It does not include Falloon. Falloon does not have an interest in this pre-LPA application. Falloon has no legal standing to be invited or intervene in this contested hearing. Falloon is not an objecting party. He didn't want Falloon involved in this substantive due process hearing, which is illegal. That's a violation of the law. The adjacent property owner has the right to object and to be involved. And the Idaho Supreme Court specifically said that unless the adjacent property owner consents, then that adjacent property owner has the opportunity to file an objection. The board shall set a time and a place for a hearing so that the applicant and the objecting party can present evidence, can present their positions. Because this encroachment is right on Dr. Falloon's property line, it's not even 10 feet away. It is demonstrated to adversely affect his property. It's unrebutted in this evidence that the erosion of his shoreline is happening right adjacent to the Wilsons' unpermitted, previously denied, repeatedly denied, and now appealed unlawful encroachment. And so to argue that Falloon doesn't have the opportunity to object and participate in a hearing runs contrary to the Lovett decision, runs contrary to Idaho code. So moving on from the IDL has jurisdiction, Falloon is entitled to object. He's an adverse party and Idaho code requires it. Now talking about the statutory requirements for a pre-LPA approval, the burden is on the applicant. The burden is on Wilson to show, and the statute specifically says through aerial photographs, through tax records, through other substantive evidence that this encroachment, unmodified, has pre-existed since January 1st, 1975. That burden is not met. There is no doubt in this record that burden is not met. There is absolutely no substantive proof of this LPA log crib encroachment existing pre-1975 and being unmodified. It's clearly been modified, and it's been modified repeatedly and somewhat egregiously. And so IDL was correct in denying the pre-LPA application for lack of substantive evidence. And this hearing body would be correct in affirming that denial because there is no substantive evidence that it pre-existed. And to the contrary, the substantive unrebutted evidence is that it's been significantly modified, constructed with rocks and logs and sandbags and tarps and plastic. And the pictures document that that did occur below the ordinary high water mark as well. We also request, pursuant to Idaho Code 58-1309, that the hearing coordinator, in conjunction with denying the pre-LPA application, order its removal, order the applicant to mitigate the damage caused by the unpermitted and unlawful encroachment, and to remediate as much as possible the erosion and the damages that has occurred. I think, as Dr. Faluna indicated, the letters from Pierce and Phillips do not provide substantive evidence that the log crib at issue exists in an unmodified form, similar or identical to what it did pre-LPA 1975. And the photographic evidence, if we look at exhibit F7, and Wilson submitted a similar picture, there's absolutely no log crib documentation as of 2005. It's none. That picture at exhibit F7 shows no log crib, no encroachment, and there's many others that show there was nothing there prior to Wilson started building this up and putting logs and rocks and tarps and sandbags. The other case that I just want to mention in the record as well is more recent, Bird versus Idaho Department of Lands. It's a March 2nd, 2022 decision, which again reiterates what has been well-established law, that pursuant to the public trust doctrine, the state of Idaho owns the bed and banks of these navigable waters. Wilson does not have any constitutional property right to the land below the high water mark of Priest Lake. Priest Lake. As a matter of law, Idaho, the public, pursuant to the public trust doctrine, owns that land. So he has no property right that he's claiming has been violated, that he has constitutional due process to, that he has not received, that he's suffering a taking. It's not his property. It can't be a taking. It's the state of Idaho's property, and it's for the public. And he's interfering and unlawfully encroaching upon the state of Idaho, the public's property, and is interfering with the public use, navigation, commerce, fisheries, environmental controls. And I think the evidence of exactly what this erosion is doing is contrary to that public trust doctrine. That has been reiterated in Newton versus MJK 167 Idaho 236, which is also a 2020 decision. So the law is clear. There is jurisdiction with IDL. Wilson doesn't have a property right. There is no constitutional violation. There is no taking. There is no due process violation because it's not his property. To the contrary, the due process protects the adverse property owner, who, contrary to the Wilson's request, does get to participate in this and does get to raise his objections. And so because this permit application does not comply with the pre-IPL evidentiary standards, and because it unrebuttedly infringes, harms, damages the adjacent property owners, it should be denied, removed, and remediation should be ordered. Do you have any questions?
I don't, thank you. So what I'd like to do is, it's 10:35. I'd like to take a 5-minute break before I have IDL put on their case. But also, if I could get that sign-in sheet during the 5-minute break. Okay. This is the thing right now. So let's come back here. Well, let's just come back here to quarter till. I don't know if we need to stop the Zoom or if you just want to keep it going.
Usually we, yeah.
Certainly,
back on the-
Officer, I'll begin recording now.
Thank you. So we're back on the record. Everything's being recorded. I'll just note that it's also 10:45 Pacific time. So Ms. Kaufman, I'll turn it over to Department of Land.
Thank you. I'll just, I have a little bit to say about the jurisdictional issue, and then I'll turn it over to Mr. Amer to present IDL's statement. On the jurisdictional issue and the timing of the hearing in this matter, a couple of things to note. First of all, the applicable statute is Idaho Code Section 58-13-12, which specifically pertains to pre-LPA encroachments. And if you turn then to the rules for the regulation of beds, waters, and airspace over navigable lakes in Idaho, which that's IDAPA 20.03.04, which we refer to for shorthand as the LPA rules. Rule 12, which would be 20.03.04.012.03, pertains specifically to the permitting of existing encroachments, which is the type of encroachment where your job, of course, is to determine whether it's pre-LPA. But that rule provides the provisions of Title 58, Chapter 13, Section 58-13-12 Idaho Code apply. And then subsection B says, any new encroachments or any unpermitted encroachments constructed after January 1st, 1975 are subject to these rules. So the rules and the timing set forth really apply to those post-LPA, post-1975 encroachments, and particularly the timing. Now, I would also note that even if the rules were to somehow apply, which they don't particularly in this situation, the applicant has argued that the hearing officer does not have jurisdiction, IDL does not have jurisdiction under Rule 30 of those LPA rules, because according to applicants, the log crib is included within there as all other types of encroachments. However, if you go up above Rule 25, which is the preceding rule, pertains to single family docks and two-family navigational encroachments. And so the type that they're talking about, when they talk about types, it's the differentiation between single family, two-family navigational encroachments and the specifically named encroachments that are in Rule 30.01, non-navigational encroachments, community docks, commercial navigational encroachments, or navigational encroachment extending beyond the line of navigability. However, that doesn't address the pre-LPA versus post-LPA status of an encroachment. So in short, on that issue, these applications for pre-LPA encroachments are processed under the standards set forth in 58-13-12. And we submit that IDL and specifically the hearing officer retain jurisdiction to consider this application. I do want to respond to just also a couple of points. The applicant said at some point something about legal making a determination about this application. That is not my role as legal counsel to the Department of Lands. I provide legal advice. Any decisions are ultimately those of the Department of Lands. The objector also made a comment about the request for hearing being untimely in this matter, that being the applicant's request for hearing. It was not, if you look at the hearing record, the applicant timely filed a request for a hearing or appeal in this matter, and so there's not a jurisdictional issue in that regard. So with that, unless you have questions for me, I'll just turn it over to Mr. Amer to present the pertinent points of IDL's hearing statement.
Thank you. I do have some questions. I've been making questions that are really directed to both of you, but I think I will let you make your statement and then I'll ask those questions just to see if you address any of them before I ask them.
Okay, thank you. Hearing officer. I am going to, since the statement has been provided to the record, I'm going to just skip to the conclusion section of IDL's statement for the record. Applicant is appealing IDL's decision to deny an application for pre-LPA encroachment. Applicant claims the existing log structure has been in place and not been modified since before January 1st, 1975. Applicant previously applied for a rock jetty in the same location as the existing log structure, and that application was ultimately denied via a final order from the director, which was PH-2022-PUB-10-001. That previous application was denied primarily because the rock jetty is considered a non-navigational encroachment that must provide a public benefit for economic, environmental, or social factors. Additionally, the proposed rock jetty application was denied because it was shown to be perpendicular to the general shoreline, as opposed to running parallel to the shoreline, like all other bank stabilization projects, i.e. riprap and seawalls. Similarly to the previously proposed rock jetty, the existing log structure could also be considered a non-navigational encroachment type that must provide a public benefit, and it also extends perpendicular to shore into the lake. Through numerous meetings and phone calls, applicant was aware that IDL would not permit the existing log structure under our current rules, and that the only path forward would be to obtain a pre-LPA encroachment permit. As such, the application for the existing log structure is not subject to the same timelines and procedures provided in sections 58-1305, 58-1306 Idaho Code, and sections 25 and 30 of IDAPA 20.03.04. IDAPA 20.03.04.012.03 and section 58-1312 Idaho Code both state that, quote, every person seeking a permit for navigational or non-navigational encroachment constructed prior to January 1st, 1975 shall provide the board with substantive documentation of the age of the encroachment and documentation that the encroachment has not been modified since 1974. Persons providing such documentation shall receive an encroachment permit and shall not be required to pay the application and publication fees established in this chapter. Such substantive documentation shall include dated aerial photographs, tax records, or other historical information deemed reliable by the board. Quote. When IDL has historically processed pre-LPA encroachment applications, it has almost always involved a dock. IDL has historic aerial imagery that we can try to use to determine if a dock was present on the property, as well as determine if the overall size and configuration of the dock remains the same. The existing log structure does not show up on the aerial imagery that IDL has for this particular area due to the scale of the photo, the size of the existing log structure, and lack of clarity. However, Idaho Code 58-1312 provides that it's the applicant who shall provide the documentation. The burden of proof is on the applicant and is not up to IDL to try and prove or disprove that the encroachment in question predates LPA. The only documentation submitted by applicant to prove the existing log structure has been in place and has not been modified after January 1st, 1975, were two letters written by existing or previous adjacent waterfront owners, Pat Phillips and Gary Fivez. No historic photos, construction diagrams, detailed descriptions of the logs, or other substantive evidence as required by Idaho Code has been provided. Mr. Fivez specifically stated that only logs were placed on the beach. He does not mention rocks or any other structures, and Mr. Phillips does not mention rocks or any other structures. The letters also do not mention dimensional lumber joining the logs by steel spikes, as described in the application by the applicant. Applicant has provided no evidence that dimensional lumber joining the logs by steel spikes ever existed before 1975. Without any evidence that supports the size, building materials, and construction of a pre-LPA encroachment, no permit for it can be granted. Additionally, based on photographs provided by adjacent neighbor Mr. Falloon, IDL believes the existing log structure has been modified since 2005. Photos show that rocks had been added to the lake bed and log structure sometime in 2006, 2007. Mr. Fivez's letter only describes logs on the beach and states, however, there was no rock barrier or rock structure that extended from the beach into the lake. Since applicant has modified remained of the log structure, the existing log structure can no longer be permitted as a pre-LPA encroachment. The application does not state a purpose for the logs, but that they're located where the prior application covered by PH-2022-PUB-10-001 sought an encroachment permit for rock jetty. As noted in items 3.D.2.C, 2.D, and 4.A of the preliminary order, the purpose of the jetty was to capture sand on the north side of the jetty. While beneficial to applicant, this interruption of sand movement appears to be harming the neighbor's beach to the south. It is possible that this interruption in sand movement is affecting other properties to the south. The preliminary order determined that the application for essentially the same jetty was not an encroachment in aid to navigation and did not rebut the presumption of adverse impact. These determinations were instrumental in denying that application and are still applicable to the alleged pre-LPA encroachment log structure. In summary, applicant only provided 2 letters attesting to the age of the existing log structure. No historic aerial imagery, or any personal photos provided that would show the extent and construction date of the existing log structure. The letters do not mention any rocks as being part of the structure. The letters do not make it clear what the logs were originally a part of. And the letters do not mention that the structure remains the same today as it did back in the early 1970s. IDL does not have any aerial photographs or tax records to prove the structure has existed in the same location without being modified after January 1st, 1975, as required by Idaho Code 58-1312. IDL does have photo proof that the log structure has been modified after 2005 by the addition of rocks and cobbles and tarps and plastic to the structure. Although the rocks and cobbles have been removed, they were added to the structure, thus altering the allegedly pre-LPA structure. Additionally, the current application states the logs are connected by dimensional lumber and steel spikes, and there is no proof or evidence of the lumber and spikes existing prior to 1975. Based on all of these reasons, IDL recommends upholding the decision to deny the pre-LPA encroachment. IDL further recommends that the portion of logs that are below the ordinary high water mark be removed prior to June 1st, 2023.
Thank you. I do have a couple questions. My first question is your letter or your summary, which the summary is fantastic, but does not address the affidavit that was submitted as an exhibit. Submitted a Patrick Phillips affidavit, exhibit M. So I don't know if this would, which either of you can address this question because it's also partly a legal question, but when you talk about substantive documentation, how would a sworn affidavit fit into that statute section?
Well, a sworn affidavit is obviously more inherently legal, at least legally reliable than an unsworn statement. I'll let Mike address the substance of what was in that exhibit.
All right. I should have a hard copy right here. Who wants a hard copy?
Sure. Thank you.
Feel free to take a moment to read it.
I have a minute to confer with my counsel outside, please?
Yeah, do you want to take a 5-minute break?
Sure.
We'll come back at 5 after 11. Yes, the best that I can.
Yeah.
Basically, if you can just develop the record regarding this affidavit and how it fits into the statutory language of substantive documentation.
Okay. So the department acknowledges that an affidavit is a much more stronger legal document than just someone's word of mouth or another letter. However, the department does not feel that one affidavit is substantial proof of the age of the structure, the size of the structure, and the purpose of the structure. When a structure or an encroachment is permitted, it would be allowed to be repaired and maintained. If we can prove that there was a dock that was a 10 by 40 dock that was pre-LPA, someone would be able to maintain and repair a 10 by 40 dock. We have no record or no knowledge of what the dimensions of this structure was. As stated before, we also have no knowledge or record of what the purpose of it was. Additionally, the two statements contradict each other in some fashion in the statement that there was no rocks present. If it was a rock crib or a crib pier, there would be rocks present. Typically, a crib is a log structure akin to a Lincoln log house, if you will, that is filled with rocks and it acts as a pier. So it seems a little odd that there'd be a statement saying that a crib doesn't have any rocks on it. Also, in order to obtain a pre-LPA encroachment, the department feels that there's a threshold that has to be met. And we feel that that threshold is a high threshold where there needs to be substantial proof. And again, one affidavit doesn't meet that substantial proof.
Thank you. Another question I had is, there's been a lot of discussion about erosion and whether there's been erosion or not been erosion. Did that fit in or matter in this type of application?
And I'm not sure where you're going with that question.
Well, there's just been a lot in your decision to deny the application, whether there was erosion or there wasn't erosion. Was that a factor in the denial?
I do not believe so. I do not believe so. It's whether the erosion or it wasn't erosion, there still is a structure or an encroachment into the lake that's not been permitted. And that structure needs to go through the permit process. So whether there was erosion or not erosion, I think the reason that there is erosion prompted the two neighbors to have their quote unquote battle, if you will, for lack of a better phrase, that really raised it to our attention. If there was an erosion, Mr. Flynn may not have contacted our office and myself as much as he had. But regardless, you need to permit the structure that's in the water.
And I have one last question. Ms. Kaufman, this may be more directed to you. So at the end of the objector's legal memorandum, there's a few requests that are made, not just to deny the encroachment permit, but also to order the removal, order mitigate damage, and order financial penalties. Could you just develop the record regarding what my authority is and under the statute and rules?
Sure. Well, in terms of the restoration and mitigation of damages, under Idaho Code Section 58-1309, that requires a court order. The specific language provides that any person legally found to be wrongfully encroaching in a lake shall, in lieu of, in addition to the penalties provided herein, be directed by the court to restore the lake to its nearest condition immediately prior to the unauthorized encroachment as possible, or to effect such other measures as recommended by the board and ordered by the court for its mitigation. So that particular process, it's not unusual for the hearing officer and ultimately a director to require that a unpermitted encroachment be removed. But in terms of restoration mitigation, unless that's voluntarily done, that does require a court order. IDL would provide recommendations regarding the extent of the mitigation. And again, that's Idaho Code Section 58-1309. And then in terms of, was there a statement in there about penalties? Was that part of it?
Yes, order the applicant to pay financial penalties for the longstanding violations. since the voluntary dismissal of his judicial claims in 2020.
So that the civil penalty provision is Idaho Code Section 15-1308 sub 1 in particular. And it provides that it sets forth the amount of civil penalties you have to have notice, and it says such civil penalty may be assessed by the board in conjunction with any other administrative action, provided that no civil penalty shall be assessed unless the person was given notice and opportunity for hearing proceeding pursuant to the APA. And so in this case, IDL has not sought civil penalties. The purpose of this case is solely to consider whether applicant is entitled to a pre-LPA encroachment permit. Any civil penalties in this case would need to occur in a separate action because that notice has simply not been provided. And in terms of injunctive relief, 58-1308 sub 1 continues by saying the board shall have authority and it shall be its duty to seek injunctive relief from the appropriate district court to restrain any person from encroaching on in or above the beds or waters of a navigable lake until approval has been given therefore. So again, that is something that is seeking injunctive relief is a matter of the court's jurisdiction and not respectfully, not the jurisdiction of the hearing officer.
Thank you.
Oh, and if I could add one more thing, so Idaho Code Section 58-1308 sub 2 also provides for a greater civil penalty for continuing violations. I can tell you it's very rare, if not almost never, that IDL seeks penalties under that provision, and also the only way that IDL can obtain those civil penalties set forth in 58-1308 sub 2 is a civil enforcement action in district.
Thank you. Let me just look through my list. I think that was all of my questions. That's all of my questions. So we're back to you, Mr. Wilson. We get the final say.
Sure. So in regard to IDL's comments on jurisdiction, I'm not sure I heard it correctly. Did IDL say that Idaho Code 58-1305, 1306, and 20.03.025 and 030 did not apply to a pre-LPA Idaho Code 58-1312 application?
So one of the difficulties with these types of hearings is there's no questioning. I'm the only one who can ask questions.
Okay, so
And
then I'll
So
respond.
you can
Okay,
comment, you can get
fine.
the final comment.
Fine. The notice of appointment, Director Miller delegated the authority to hold the hearing. In that notice of appointment, he specifically indicated that your authority exists within 58-1306 C principally and Idaho APA 20.03.04.030. And 030 is titled Processing of all application of all other types of encroachments. If you look at the LPA, for the purposes of generality, there are three types. There's the 1305, generally navigational application. There's the 1306, which is the non-navigational application. And then there's the 1312, a pre-existing encroachment, whether navigational or non-navigational. So the question is, what's the processing procedures for 1312 application? Basically, if I heard this correctly, there aren't any. So when I argue that there's no jurisdiction because this 90-day time limit under the 03005 hearing, it says it's going to be 90 days. So do we just carve that out because it doesn't look good that we missed having the hearing? I can't believe that's the law. So I would suggest to you that this processing of applications for all other types of encroachments applies to 1312. And that's where your authority exists. And it says in subsection 5, notice of the time and place of the public hearing of the application will be published by the director once a week for 2 consecutive weeks in the newspaper of the county in which the encroachment is proposed, which hearing will be held within 90 days from the date the application was accepted for filing. This application was accepted for filing June 15th, 2021. And today is day 552 since the application date. Now, IDL is arguing that the limitations don't apply. I think that's wrong. These procedural guidelines are built around procedural due process. And the 14th Amendment protects that. So that's my answer to that. As to the affidavit from Mr. Phillips. So there's been a lot of talk about having locks on this log structure, as I've called it, because we don't really know what the log structure is composed of primarily, because it was buried in lake gravels until Dr. Falloon took out his large concrete pier. And his beach eroded, and my beach is eroded. Well, our beach is eroded at least 8 feet from where it was. And what's happened is that log crib, as I call it, which means a log structure, as it's shown in the inspection report photographs, and I think you just see one long log. Well, since that was taken, it's eroded away. And there is a second log, and then there's a cross member. But I don't know the scope of that. I have no idea what it was used for. All I know is that I've got an eyewitness who's lived there since the 60s, who said, yeah, I recognize that structure as the one that existed in 1966. I mean, that's a reasonable response. That's 55 years of recollection. I think personally, that's good testimony. And I don't think substantive documentation necessarily means multiple pieces. It could be a single piece if it's credible. And I think that's what this affidavit is, because it's a sworn statement that lends credibility to his recollection. And none of this other stuff makes any difference. There are no aerial photos. There's not an aerial photograph from the year 2000 that has sufficient resolution detail to even see anything, let alone a wooden structure that has been principally underwater and buried. If we go back and you look at that single shot that the staff took when they made the inspection on April 30th, you just see a single log and a lot of little tiny gravels and sand around it. There are no rocks. The only rocks that are there today are the ones that have been exposed by the erosion in the last 2 years. And what you see on the beach is basically the weight of us taking all those rocks off, which we put some of them on, but there were some that were there also before. Not a great deal, but there were some old broken concrete that had been put at the foot of that I took out because I didn't think it was natural enough. You know, and I suspect it'll subject the logs to erosion and ultimately they'll disintegrate. But all the rocks that you see in these pictures on the beach, they were above the ordinary high water mark when we moved them there. And I told Mike Amer, I said, Mike, since we took them out in the spring, we didn't know where the water line was going to be. Look, if they're below the ordinary water mark, we'll move them. The picture that you saw where we put a tarp down, that tarp was put down on May 27. And I snapped a photograph on May 27th from the USGS site of the lakelet on May 27, 2021. The lake was at summer pool, and the tarp was installed. It's a small 4x4 tarp. Was installed above the ordinary head. When Ryan, whomever came, I think it was Ryan. I think it was 2022 when I put down. Anyway, at At the time that I put the tarp on, it was put above the ordinary high water mark. And that's the exhibit that I sent in this morning. That's titled Exhibit. It shows that documentation. Pile of rocks on our beach, that's all upland, most of it. Some of them have now become kind of in the lake on our, at the lower end, the lakeward side, but that's recent erosion. You know, and I haven't done anything with it other than try and reduce the erosion that we experienced. We didn't do anything here. They'll remove the concrete pier. He was warned he would have substantial shoreline erosion. He did it anyway. That's fine. We didn't do it. The rock that you see there, we haven't done anything in the last 10 years. After he removed it, I did add some additional sandbags to try and reduce shoreline erosion because it was just eating away our shoreline. And we've lost 7 or 8 feet of beach and sand. You know, when we bought the property, he had a nice beach and we had a nice beach. And after the pier was taken out, his beach went away and mine started to go away. And now I've become the bad guy. So I tried to get a riprap application. Maybe it was the wrong thing to do, but they said they approved it. And then they reversed their position. That's one of my exhibits. But Pat Phillips is that wooden structure, however it might be described. 2 logs, 2 cedar logs, I don't know, fir logs with cross members. You know, we didn't excavate it to determine the scope of it. I don't know what it did. When I spoke with, we made a big effort to find Red Rouse's brother, and his relative. Apparently he died around 2001. His wife died in the late 1990s. But I did find his daughter, a lady named Joanne England. And she lives in Priest River, and I met with England this summer. Eugene England, he was an 85-year-old man who just got back from cutting firewood. It's amazing physically. And I showed him the pictures, and I said, you know, do you have any of that? And he said, all I can tell you is I remember Red Rouse talking about putting something in to stop shoreline erosion. And I said, you remember what decade that was? And he said he couldn't tell me. Which isn't surprising. I can't tell you what the decades are anymore either. So, you know, between that and Pat's testimony, and then you've got Vivez's corroborating testimony that there were 2 logs. Well, there were 2 logs there. They're embedded. They're buried. And they're being exposed. If you look at that, one of those logs is still principally buried, and then there's this cross member with a spike in it that has become exposed since we removed all those rocks, according to the order. But this structure plainly has sufficient evidence to support the position that was there before 1975. It doesn't really do a lot of good. If you look at the beginning pictures from 2004 to the last ones Bill showed you, our beaches have almost synchronized, you know, in terms of equalizing the sand. Sand's not static. I mean, I live on it. The erosion takes place at the shore break. That's a foot above where the water is and a foot below. Beyond that, it's all gravel. My beach is all gravel. You look at the beautiful sandy beach, the sand's 2 inches deep. Under that is gravel. When wave action comes, it lifts the fine material and lifts it up. So in the springtime, when you get high water, you have beautiful white sandy beach building because all the fines are being pushed up. The gravels, they stay at the shore break, you know, unless your beach is so flat that they spill back in. You know, and the problem with Bill's beach, his beach is steep. And he used to have a bulkhead along the front of his 75 feet. And it's just steep. Sand is never going to accumulate there. If it travels south, it's gonna, and it has gone on Aspen's property. But this structure, whatever it is, whatever it was used for, exists, and it does mitigate some shoreline erosion for us right now. And I think as a result that I'm entitled to 1312 status. You know, if I have to go to district court or the Supreme Court to argue what does substantive information mean, I covered this a little bit in my brief. You know, there was a there was a case that discussed the meaning of most unusual circumstances, which is used in this 1305 statute, which is what I can just have that discussion this afternoon. That basically says you just go to the plain language of the statute and you look at the common meanings of the words. So I think Ideal's argument that we didn't produce substantive documentation is wrong, because I think one piece of the evidence can be sufficient to prove that it's more likely than not that it was there. And the affidavit adds the reliability. Because under 1312, they have to deem it reliable. Historical information, aerial photographs, technologically an impossibility of performance. Tax records, really not applicable. Other historical information being reliable by the board. That can be anything. And it's after making an exhaustive search, that was my conclusion. That's enough to prove that it was there. I'm not even able to describe it on a permit adequately, because I don't know. We haven't measured it. I could have an engineer go out there and draw it up, but at this point, I don't think I want to do that. But that's really kind of all I have to say about Ideal's presentation. I'd like to go back to Dr. Williams if I could.
You have final comments for anything that was said.
So Ms. Fulgham ended with this statement that we don't own the beach. And I think it was the Hudson case that makes it pretty clear that I own everything to the ordinary high water mark as it existed in 1890 when Idaho became a state. And it was that ordinary high water mark that is subject to the public trust doctrine. Ideal has the ability to manage the lake beds from the artificial height, which is what we all use today. Bill mentioned the elevation was 2437.64. That is the artificial high water mark. And they do have that right of regulation. But in terms of ownership, we own to that 1890. There hasn't been any official determination on where that was, but it is probably somewhere close to Winter Pool. So all of that sand that's moving away is part of the real property that's on my deed. And I believe I'm entitled to protect it, especially since I didn't initiate these erosive actions. So if we have to argue about what I own, I just want that on the record so that I have something to appeal. I can go through all these. I made notes on all these photographs. I'll have to get back in. I think the most telling thing is if you look at the public trust inspection report photographs, you'll see this long string of log that's got kind of small gravels around it. We haven't added anything. What you see now in some of these photographs are some gravels and other rocks, but those are just the result of the lighter, smaller materials being moved around. And if you look at his beginning pictures and his end pictures, you're going to see the beaches are only offset maybe a foot at this point, whereas they used to be probably 8 feet after he removed the concrete pier. Picture F7 was a 2005 photograph, which I think needs to be enlarged because it does show the shadow of this rock wooden structure under the water. F5 is an aerial photograph from the Bonner County Assessor's Office, which argues that our beach is actually much larger than it is. And that was used as evidence to show this distinction that we have this big beach and he has this small beach. He always had a smaller beach because he had a very steep lot. So that photograph can contain some yellow fading. Our beach in an aerial photograph would be crescent shaped. That was straight across. The rest of these pictures, oh, the log on the beach, the log floated onto his lot. I'm there all the time. He comes up occasionally on weekends. In the springtime, we get a lot of material that floats around. I used an awl because it was waterlogged, and I put it up on the beach between us. It cut up for firewood for the firewood. It wasn't there as a barrier. It weighed 400 pounds. I couldn't move it. You know, the sandbags, you know, they help. He should use sandbags because when you get the high water erosion, your upland beaches are being eroded from flooding. You know, you should protect them. Sandbags that are upland of the ordinary watermark are not regulated by IDEA. It's like a sailboat or a hovercraft parked on a beach. If it's 10 feet or shorter, it doesn't require anything other than an invasive species sticker. So that's not a problem. I can take my 16-foot hovercraft and park it over there. It's currently permitted. I just didn't want to make it the fight worse than it was. Bill talked about the flow being from the southwest to the northeast. That's generally true. We have a southwest prevailing wind and it will move fine material to the north. But we also get storms from the north, and most of the summer we have an erratic wave pattern. And that erratic pattern is coming from weak surfing boats that leave 2-foot breakers coming in onto the beach. And they're coming in all different directions. And they can be really damaging in the spring when the lakes in flood. Most of this year, 2022, the Department of Water Resources, they kept the Priest Lake 2 inches above summer pool as a reserve in case we had a bad fire season. So most of the time, when, for example, when Ryan Zandhusen went out and took a picture of my tarp and filed a report that I was a violator, I immediately wrote a letter to Mike Hamer. I complained that I wasn't given notice that there was going to be an administrative search as a courtesy. I mean, they've given Bill everything to see a copy and do anything I do. But Mr. Zandhusen was wrong. That tarp was set at the ordinary head watermark on May 27th, which was the only day last year when the lake was at ordinary head watermark, or IDF's jurisdictional level. 2 times in the year, May 27th, and this fall when they dropped the lake after October 10th. So all those summer pictures where you see water over the tarp and around the rocks, they were in compliance when they were put in. And I can't control it. One of the pictures in there, Bill asserted that the bride of my youth, Deborah, told him we have 60-year-old photos. That's absolutely not true. The photograph that he shows here was F20. That was a party was held for that. My son had graduated from Notre Dame Law School in 2010. That was his summer graduation party. We were sitting on the beach. F-35 shows 2 logs, and now they've been exposed to erosion. And I don't have any barriers. You know, I know that Bill would like to see me remove all those rocks on the beach, and I will someday. But I'm busy. I got a lot of stuff to do, and I just haven't gotten around to hiring somebody. I think it looks ugly. It's not a permanent plan. And then this about no log structure existing before 1975, something I'm sure. I didn't put it. I've never touched that structure with a hammer or anything. The fact that nobody saw it was because it was buried. Mills Beach lost at least 12 inches of sand and gravel between where its old pier was and our ground wall. We eroded at least 12 inches, and that erosion has spilled over onto our beach, and it has uncovered a lot of that log structure. Now, photograph F41 is a draft of the 2021 permit. 2021 permit sought to permit the boat rail system, which had been located on the lot we purchased to the north. I replatted our lot and added 40 feet to lot 17. So in the process of the replat, I now had an encroachment on lot 17A, as it's called, that was unpermitted. So I completed the application process for that. And that, which we may talk about this afternoon, that permit had 3 revisions. 3 drawings were revised. F41 and Bill's presentation was draft 2. Draft 1 had circles written as rocks over the log crib. That was draft 1. And Trevor Anderson told me that legal had reviewed it and said you can't have that. So I removed it. Draft 2 showed the 2 logs that Mike Vivas talked about. And I didn't put cross members on it because we're just trying to rough it out. And Trevor Anderson said remove them, so I removed them. That permit was issued. F40 dated 5/31 of 2021 shows a plastic on the upland beach. I can do whatever I want on my upland beaches. IDL doesn't regulate my upland beaches. And it may look ugly, but I didn't know in the springtime if high water was going to go back, up around, it covers the whole beach sometimes. And it does a couple of things. It prevents all the crud that comes out of the creeks. I mean, we get tremendous amount of organic material in the springtime. I mean, interesting. It protects that, and it also protects from erosion. And I covered those rocks with a tarp. Just because I didn't want them to fall over on his lot, which they did, because of the wave action. You look in F51, the stand that he said was on my lot, it's all gone. It eroded away. Plus 8 feet of beach. I was unaware that Bill had objected to the June 15th, 2021 application. I actually made a public records request, and that was not included in it. So go back to this, there was a 90-day period from June 15th, 2021, when this thing had to be processed according to this hearing requirement in 2304 30. That wasn't done. F62 ski lifts I recall pulling them above the ordinary high water mark. I have had some physical issues with my elbows and my back. Have been unable to do some of the physical things that I used to do when I was 50. I'm 71. F-68. It shows sand. Now, on Fulton's Beach, where in earlier photos, he said there was none. So sand moved onto his beach. Fine. F-69 is another picture with sand on his beach. The sand's not static. It goes all over the place, depending on the website. F-70 shows two pictures which are really taken from different perspectives, which improperly suggest that our beach was greater than his in those pictures. In those pictures, they're pretty close. They're taken from the same perspective. Picture F-71 basically shows our beach is almost equal in terms of sand deposition. F-72 shows Wilson's beach eroded. F-73 is a high water picture, way beyond the ordinary water mark where IDL would be concerned. Picture F-75 shows the tarpaulin. Exhibit O is going to show that it's put in above the ordinary high water mark. And that this June 29 inspection report that criticizes me for being a recidivist violator of IDL's rules was simply wrong. And I pointed that out to Mr. Anger immediately. Picture F-79 again shows equal beaches in terms of sand. So does F-80. The beaches have come to equilibrium. Then I should point out too that Bill and I spoke. I mean, I really make an effort. I think I made an effort to try and reconcile this. Bill he won't speak with me. He will only communicate by email. And that's not what I do. As a lawyer, I just don't do that. For a neighbor, I want to talk to him, he won't talk to me. So this late this summer, I went over and grabbed him. I said, come on over here. You know, he shook his hand. And I said, let's talk about this. And I think it was during this time that I had the peer extension application pending. I said, Bill, I'll make a deal with you. You consent to my peer extension permit. I'll pull off the law credit. Will you do that? My recollection as at least the result is the answer is no. And then responding to Ms. Fultram's statement that there are no automatic approvals of any permits, I would like to refer you to Idaho Code 15-1305, so paragraph G. This has to do with a navigational permit. It's got a 60-day time clock on it. It says the board shall act on the application as expeditiously as possible, but no later than 60 days from the receipt of the application, and failure to act within such time constitutes approval of the application. Well, this is in the 1306 type hearing. But there are instances of automatic approval. I can't tell you, I don't know what happens to 1312 application that runs through the 90-day limitation of the 030. I just think IDEA loses their jurisdiction to do anything. I don't need a permit for that if it exists for January 1975. One reason I asked for a permit is because they made me. So I don't know the answer to that. I think you get one shot at me here. I was compelled. Trevor Anderson said, you file it by the 23rd of June, or I'm going to send you a non-compliance letter and ultimately we'll end up with an enforcement action and be in civil court in district court. I don't want to do that. I got to get into this process, this judicial process. And the only avenue is to come through an application. At this point of the hearing, to ask you to rule fairly on the information. And if the ruling is, to my view, unsatisfactory for some legal reason, I then get to go into district court. And the Newton case that Ms. Alvin handled was a great case. I mean, Newton sued IDL and others in district court, and the court said, "Look, you don't get to do that. The only avenue to an appeal, an IDL permit or a ruling is you have to be in this administrative process." Now, I knew full well when I asked for this appeal that the time limits had been blown. And my request for this hearing wasn't any kind of a waiver of that right. I just don't get to argue this. I'm in this setting. And I think they've missed this very important procedural due process violation. I would claim to have a property right in the wooden structure and in the sand. The IDL does not own to the summer pool level. They own to the Oregon high water mark as it was in 1990. I don't know where that is. They don't, and I don't personally want to argue. But I can tell you this is close enough to the ordinary water, artificial water, to make that continue. That's all I have to say. Thank you so much.
Can I make one point of objection on the record?
1 second. I have a couple things I want to do first. If I forget you, please come back. Remind me in a minute. First of all, one of the things I wanted to do before Mr. Wilson went again is just to say that I've looked at the comment sheet and everyone who's wanted to make a comment has testified today. Testify is not really the right word in this type of hearing, but has spoken today. I do have one more question for Department of Lands. And then you still get the final comment. So if I, then I'll allow the objection, then you still get final comment. It's really a clarification. This is Dr. Balloon's survey. I believe it was to the high water mark. Is that the survey?
Yeah, I think you said
Sure.
Go ahead, if you know what it is.
I think you said the
Oh,
pink.
go ahead, let Mr.
pink-
Emer.
The pink was a property line, and the blue was a high water mark.
So, and then I'll just say this is slide F81. So just for clarification for the record, we're talking about this right here,
Correct.
right? Okay. I just want, and it's the part towards the water.
Yeah, water can cross like that,
Okay.
so it'd be everything below that.
And Machine, if I could too, I want to make a point about the artificial versus the ordinary high water mark.
That'd be
on the
great.
pre-slate. It has not been judicially determined whether there even is an artificial high water mark. The Hudson case did not decide that issue. The situation on Priest Lake, and it's kind of unique among Idaho lakes, is the accepted high water mark, or the one that IDL claims jurisdiction to, is 2437.64. And it's never been judicially determined whether that is the ordinary high water mark or the artificial high water mark. In terms of the state's ownership, the location of whether it's ordinary makes a difference, but in terms of its regulatory authority, it makes no difference whatsoever whether that mark is artificial or ordinary, but it has not been judicially determined.
Okay. Thank you. I just wanted, there's been so many pictures of really the beach and the rocks on the beach. So I really just wanted the clarification that that's not what this hearing is about today. It's about what's, as you pointed out, a little bit above the survey marks and then into the water.
Correct.
So I just wanted that clarification for the record. So Ms. Full Jam, you said you wanted to make objection, I'll allow you to make an objection for the record.
Okay, the objection, and I want to cite some legal authority just because I think it might be helpful based on the question that you asked counsel for IDL about the substantive evidence standard, and which is what's required under 58-13-12, and an affidavit in order to be evidence under the Idaho Civil Rules of Procedure, and I agree, we're not in a evidentiary proceeding, the rules of evidence don't apply, but to the extent that it's helpful by analogy.
So actually, let me stop you a minute. So your objection is, I guess I should ask, what is your objection? There's normally not objections in these types of hearings, but I thought it was going to be a general objection.
It's an objection to the testimony or the purported testimony of the witness, Pat Phillips. It is not reliable.
Okay, I'm gonna stop it then. So I'm not gonna allow you to do that type of objection. Because this is not, it's not even a formal administrative hearing. This is a public hearing.
Right.
So I thought it was gonna be, sorry, I should have
Okay, well,
asked that question.
let me just address the legal standard that you just discussed with counsel then, because the substantive documentation requirement is contradicted by the language in Phillips's letter, where he says on February 22nd, 2020, that I recall the law structure.
I'm not gonna let you get into Mr. Phillips' letter.
Okay, for purposes of the record, then it's not reliable, it's not credible. His recollection is contradicted and should not be the grounds.
Okay,
I understand, I will ignore that.
it's my mistake. I should have asked you what type of objection you were raising before I let you go forward. I thought it was gonna be something a little bit different. So unfortunately, I'm a litigator by history too, so I sure raise an objection, but it's really not appropriate in this hearing today.
I understand. The last point addresses exhibit F81, which you were talking to Mr. Amer about. And the ordinary high water mark survey stake that's in the picture, which shows the modification and the changes of the rocks and the logs and the sandbags below it. That high water mark stake was put there by Jeremy Russell, surveyor at JUB, and he put it at 2437.6. So those encroachments in F81 are below 2437.6 as documented in those exhibits as placed by Idaho licensed surveyor Jeremy Russell.
I appreciate your clarification. So Mr. Wilson, now you get the final say. If you don't need to go through anything you've already told me, but anything
I'll
like
just hang into this ordinary. JUB Engineering, Jeremy Russell, had come out and surveyed an ordinary watermark 4 years ago. It would have been 5 or 6 feet further into the lake. Ordinary high watermark changes with erosive and accretive activities. It is not. Give me a really good example. The Department of Lands has just sold huge quantity of property on Priest Lake. Mr. Russell's company did a good portion of the survey work. And they surveyed the western boundaries of the eastern lots. And I'm going to use an example of Desmet Park subdivision, which is located just north of Dunn Park. There were 3 lots in there that were surveyed and sold privately. And Mr. Russell surveyed the western boundaries as the ordinary high water. That's all that's on the survey. No pins put in for good reason, because they erode. But normally when you do a land subdivision, you would put in a survey marker on the western boundaries upland of the ordinary high water mark, so as to avoid your survey pins being eroded. Now, the law in Hudson case is the first one that comes to mind, because I'm good friends with John Henderson, who handled that case unsuccessfully, I mentioned. But survey marks are put upland. But the literal owner owns to the ordinary high water mark as it existed in 1890, before they put the dam in. The dam raised the lake level. So when you put a man-made structure in the lake and raise the lake level, wherever the lake level stops, that's the artificial high water mark. It is 2437.60. The correct term is artificial high water mark. IDL doesn't like to use that. You know, we have this problem here, and I don't want to be the one that goes to the Supreme Court with the question of what I own. And the applicability of public trust doctrine and all that other, but it's an unknown location. It's not a static location. It's in flux, it moves. So when you have this, in the example here, Dr. Floon had the survey marks put on his frontage. And my ordinary high water mark probably extends out a foot or two. And he wants to say that his ordinary high water mark should go across my lot. My ordinary high water mark is different. Because that beach has been there for 60, ever since his pier was put in. It's been there a long time. And I'm just saying that you can't say that that survey pin is anything other than Bill Balloon's ordinary high water mark. It's not my high water mark. My beaches are different. Now, if I were compelled or ordered to remove the log crib, our ordinary high water marks would join at some point through erosive action, and there would be one straight line. But I've been trying to protect the lovely beach that my children, 2 of my 4 children, help clean every year and remove rocks and things like that from erosive activity. Bill took out a big pier, and he had a beautiful beach there, and our beaches were nearly the same. I admit the rocks that I put in there over time, part of those were from clearing off from the beach so that kids and grandkids can still live those. And so have maybe 26 other families in Diamond Park, because there's a lot of these spurs. So he removed the pier, started the whole erosion thing, then he blames me for it. My little structure prohibits my beach from erosion. It doesn't stimulate his erosion. His erosion was caused by his actions. And I'm doing everything I can to minimize my erosion. And I'm failing, I'm losing the battle. And it's unfortunate that we have this problem. But even if I were to be able to permit these logs, in 2 or 3 years, it's probably going to be a foot difference. His ordinary water mark is going to be 12 inches closer to the upland side. Mine's going to be 12 inches out. That's just the way it is. You can't count on these surveys and extrapolate and say it just goes across the line. It moves, it changes. And that's why IDL didn't describe the surveys of anything other than going to the ordinary high water mark, because they don't know where it is. It changes. So it's wherever it is at any one point in time. Erosion reduces it, accretion increases it. I get a storm in there and it changes. That's all I have.
Thank you. So that's all the testimony today. So the next step is I will adopt a preliminary order. My order only goes to the director. The director then reviews it, decides if he agrees or disagrees with it, and we'll draft a final order, and my preliminary order is attached to his final order. So we're just going to mark the time as 12:02. So thank you everyone for your participation today, and we are adjourned and we're off the record. Thank you.
Thank you.